Mr. Lewis, you have Crystal Vogan, this is sentencing. Good morning. This is Mr. Hoffpower sentencing. I didn't see you over there, Mr. Hoffpower. Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or?
There's a lot of history, we understand, Your Honor, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if
I
anything?
haven't done nothing. I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of
Yes,
criminal
ma'am.
history?
Because it's deferred, yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
Before we even get into the facts of this case, understand this. What you're about to watch is a masterclass in how a good plea deal can completely fall apart because someone simply cannot stop talking. This defendant walked into court with what most people would consider a gift: deferred adjudication, probation instead of prison, and a real chance to eventually wipe the conviction from her record. That is not common, especially for a felony theft case involving nearly $10,000. But here's the problem. Judges don't just look at this charge, they look at patterns. And when a judge starts flipping through page after page of criminal history, that patience wears thin fast. This hearing goes from routine sentencing to full courtroom chaos because the defendant doesn't read the room, doesn't respect the process, and worst of all, doesn't know when to stop arguing.
Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, Your Honor, that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the recording.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That
was
was,
9,400 that from within the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of
I
the,
don't have the other cat of another person, Your Honor. This is one that's the charge. I'm not coaching on there. But she's responsible.
yeah. So I mean, if there was another person, and you didn't give that
I
information,
don't
then
know.
that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was the one that called. Side, whether or not she had a conversation. The backside is not, to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm going to do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly.
This is the moment the entire tone of the hearing shifts. Up until now, this could have stayed a quiet, procedural sentencing. But once the judge mentions multiple pages of criminal history, that's no longer background noise. That's the main event. Judges are human, and when they see repeated offenses spanning years, states, and similar conduct, they don't see rehabilitation. They see risk. What's especially damaging here is that none of this history is disputed. These aren't dismissed rumors or misunderstood arrests. These are convictions, probations, and repeated chances already given. So when the defendant tries to redirect the conversation toward restitution or personal progress, the judge isn't being cruel by pushing back, she's being responsible. The court has a duty to protect the public, not just reward promises of future improvement.
I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 hearings and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
This exchange right here is where credibility starts to crack. The defendant is trying to present herself as someone moving forward, nursing school, employment, responsibility, but the judge isn't buying the narrative at face value. And here's why: courts deal in reality, not aspirations. When a judge asks whether someone with this type of criminal history can realistically enter a medical profession, it's not an insult, it's a legitimate concern. Healthcare positions require trust, licensing boards, background checks, and ethical standards. A long history of financial crimes and ongoing probation doesn't disappear just because someone wants a fresh start. This is also where defendants often make a mistake by talking too much. Instead of letting their attorney frame the argument strategically, they jump in emotionally. And emotional responses in a courtroom don't build credibility, they erode it. Judges notice tone, deflection, and whether someone accepts responsibility or just keeps explaining.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
Just one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say that.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the bailiff.
Who's on me like that?
This part matters more than people realize. Restitution isn't just about paying money back, it's about honesty, accountability, and cooperation. When numbers don't line up, judges immediately start questioning the defendant's truthfulness. Here, the issue isn't whether the defendant personally withdrew every dollar. Legally, that doesn't matter. If you're acting together in a criminal scheme, responsibility is shared. Trying to distance yourself from parts of the loss only makes it look like you're avoiding ownership. And avoidance is poison in sentencing hearings. Judges want clarity. They want acknowledgement. What they don't want is finger-pointing or technical excuses. Every attempt to shift blame just reinforces the judge's concern that probation, especially deferred adjudication, may not be appropriate.
Call Mr. McCoy's case. Mr. McCoy? Our conversations are concluded.
Mr. McCoy is here today. I've revoked his release based on his new charge. He held without bond on that. What else do we have? And Mr. McCoy, you understand that you're representing yourself. I have found you competent to represent yourself. At any point in time, these procedures, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. Looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request that my bond reinstated, sir.
Motion denied.
And reason being, sir, can I please have an explanation why
Because you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted the case, that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up a fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker, but however, you did enter a plea. And that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and that I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on the proceedings, sir.
When a judge says, "I just can't believe I'm even considering doing this," that is a warning siren. That's the sound of a plea agreement hanging by a thread. Judges are not required to accept plea deals. They can reject them outright if they believe justice isn't being served. And that's exactly what's happening here. The judge isn't debating probation versus prison. She's debating what kind of probation sends the right message. Deferred adjudication is essentially a second chance with an eraser attached. Complete probation successfully and the conviction can disappear. For someone with this record, that feels like rewarding repeated behavior rather than correcting it. This is the crossroads moment. Everything from here forward depends on attitude, restraint, and respect. Unfortunately, those qualities are about to disappear completely.
That's with Mr. Frank Sullivan. I'm not looking for help. All the thing I'm asking, sir, is why am I being denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case,
Okay.
and they will only be an assistant.
I've heard this argument for the ever since you've been arrested, so it's already part of the record. I've already made my ruling. You've already appealed that ruling, so we'll see what the first DCA says. I'm gonna set this for a pretrial June 19th at 9:00. That'll conclude the hearing. Okay?
Well, sir, I still had a couple things I really wanted to say for the record.
Say them on the 19th.
Seriously, come on, Mr. Clark, man.
What do you want to put on the record? I'm gonna give you a minute. Go.
All right. The whole thing I want to put on the record, Mr. Clark, is I don't know what kind of beef that you got with me, sir, or Mr. Frank Sullivan, but I keep having multiple prosecutors filing motions against me, the ones that was pulled off of my case. Why they still filing motions
Mr.
against me?
McCoy, I understand that argument.
But it makes no sense because it seems like my case is going nowhere,
Listen,
especially when you have nothing to even try
These
to
state
do.
attorneys don't stay here very long. The ones that are on your case are in another division. I have nothing to do with that. Mr. Sullivan has nothing to do with that.
He just said he does.
Huh?
He just said he did, though.
No, what I said, Mr. McCoy said that despite who the prosecutor is, you're also involved in my case. And I said, yes, that is true because I'm the division chief.
He's
I didn't say I had anything to do with moving prosecutors or changing.
he doesn't move, but he is the division chief, so
Okay, if
request.
my old prosecutor's already moved to a different division, whatever, why is she still filing motions against me? And then obviously when she signed it, she said this motion is for Frank Sullivan.
They all sign it for Larry Bassford. It doesn't matter who signs it, who files it. They were filed on behalf of Larry Bassford. So that's going to conclude today's hearing.
That makes
Y'all
no
go ahead
sense,
and
Mr. Clark.
Mr. McCoy, that concludes the hearing. I understand. There's nothing else to be said about that.
At this point, the courtroom is no longer debating facts, it's documenting patterns. The judge isn't listing charges to embarrass the defendant. She's doing it to explain her reasoning on the record. Each offense reinforces why leniency feels unsafe. Notice how the defendant interrupts, corrects, and minimizes instead of listening. That's not asserting your rights, that's alienating the decision maker. Judges expect defendants to hear hard truths without arguing every detail. Every interruption here chips away at any remaining goodwill. And when serious charges are brushed aside as misunderstandings or technicalities, judges take that personally. It signals a lack of insight into the harm caused, and courts punish that far more harshly than silence ever would.
This is State of Florida versus Devontae McCoy, case number 24 CF 2543. and 24, CF 2544. Mr. McCoy has made the decision to represent himself. Mr. McCoy, do you wish to continue to represent yourself?
Yes, sir.
We're set for a pretrial today. Where we at?
I filed a few motions, Your Honor.
I've denied the motion to set bail. I've denied the motion to quash order to revoke bond.
Okay, Your Honor, can the state at least, or can somebody at least explain to me why I deserve to be held without bond?
No, sir. I've already done that, and I've already made the decision. You're being held without bond because you were arrested on a new charge and you pled to that charge. And I've already discussed that. So we're not going to have any more discussion on that.
Well, Your Honor, I would like to state for the record, due to the fact that, you know, it's on record and also by the person that actually committed that crime that day.
I've already heard that argument that you were
Mr.
making.
Clark,
Listen to me. I've heard the argument that you were a peacemaker, but you pled to that charge. We're not hearing anything else about setting a bond or anything else.
I never pled
What else
guilty
do we
to
need
that
to
charge,
address
Your Honor.
today?
Well, I put in a motion to dismiss the information due to double jeopardy clause.
That will be denied, but I'll get you a written order.
Well,
or anything else.
can I, wait a minute, Your Honor, I need to state something for the record. I mean, I'm trying to understand why is my motion being denied without being heard.
I'm gonna
Not
get you a
hearing
written
my
order.
motion, Your Honor.
Anything else besides?
Yes,
this order?
I'm trying to get my motion heard. I want my motion to be heard, Your Honor. I want to speak.
I'm gonna review it first because I'm gonna get you an order. I'm gonna get you an order, and if you want to do a motion for rehearing, you can do that. What else we need to do today?
I want my motion heard, Your Honor. I want to speak.
What else we
based on my
need to
motion.
do today?
I'm going to speak on my motion, Your Honor.
All right, let's go ahead and set it for trial. We're gonna set it for trial October the,
You setting for trial? I'm trying to discuss something with the
what's the
state,
trial
Mr.
date?
Clark.
you have time to negotiate between now and then, October 6th. And we'll set it for a trial management, August 21st at
Well,
9 o'clock.
Wait a minute. Also, what about
Thank you, Your Honor.
that's not my last motion. That's not my last
Mr.
motion.
McCoy, that's all we're gonna take up today.
What about my motion for by my evidence, Your Honor?
I've already denied that.
Motion to preserve evidence? How can you deny a motion to
And
preserve?
I'll look at that. I haven't seen that yet. It's filed, but I have not seen it. That'll conclude today's hearing, Mr. McCoy. We'll see you.
I filed that a month ago.
Yes, sir.
Go and go.
Mr. McCoy, it wasn't sent to me, so that'll conclude the hearing.
So you sent me for trial.
That
and I
will
didn't have
conclude
nothing.
the hearing.